Welcome everyone to Law Books Simplified, and as we all know, here we are going to simplify the book CPC by C.K. Takwani. And in this book we are going to go through every line of every paragraph of every page of this book. And as we all know that CPC is a little bit technical and tricky, so I'll try to explain them and make it as easier as possible for all of you. So on the last video we have done till the first part of the 10th page, and today we are going to start with retrospective operations. So let's move on. It is well settled principle of interpretation of statutes that procedural laws are always retrospective in operations unless there are good reasons to do the contrary. Their provisions will apply to proceedings already commenced at the time of their enactment. The reason is that no one can have a vested right in forms of procedure. The Code of Civil Procedure is not retrospective in operation. So what it says is, normally all procedural laws are retrospective in operation, but in this case CRPC we see that it cannot be applied on the cases which have been filed earlier before the commencement of this act, because nobody can have procedural law as their vested interest. So that's what it says, and this is a very important point to be remembered, because many times it has come to the preliminary exams of judicial services that is CPC retrospective in operation or not. So let's move on to the code at a glance. It is the last segment of this video and of this chapter, so let's do it. The substantive part of the Code of Civil Procedure contains 158 sections. The first schedule comprises 51 orders and rules providing procedure. Appendix contain model forms of pleadings, process, decrees, appeals, executions, proceedings, etc. Section 1 to 8 are preliminary in nature. Section 1 provides the commencement and applicability of this code. Section 2 is a definition clause and sort of statutory dictionary of important terms used in the body of the code. Section 3 to Section 8 deals with the constitution of different types of courts and their jurisdiction. So these sections, these orders, we will read them harmoniously in the upcoming chapters, and it's just an appendix, and by going through this we can have quite a view of this subject of this book. Part 1, Section 9 to Section 35B and Orders 1 to 20 of First Schedule deal with the suits. Section 9 enacts a civil court has jurisdiction to try all the suits of civil nature unless they are barred expressly or impliedly, whereas Section 10 provides for stay of suits, doctrine of res sub judice. Section 11 deals with a well-known doctrine of res judicata. Section 13 and 14 relate to foreign judgments. Section 15 to 21A regulate the place of suing. They lay down rules as to jurisdiction of courts and objections as to jurisdictions. Section 22 to 25 make provisions to transfer and withdrawal of suits, appeals and other proceedings from one court to another. Order 1 to 4 deal with institution and frame of suits, parties to suits and recognized agents and pleaders. Order 5 contains provisions as to issue and service summons. Order 6 deals with pleadings. Order 7 and Order 8 relate to plaints, written statements, set off and counterclaim. Order 9 requires parties to the suit to appear before the court and enumerates consequences of non-appearance. It also provides the remedy for setting aside an order of dismissal of the suit of a plaintiff and of setting aside an ex parte decree against a defendant. Order 10 enjoins the court to examine parties with a view to ascertaining matters in controversy in the suit. Order 11 to 13 deals with the discovery, inspection and production of documents and also admissions by parties. Order 14 requires the court to frame issues, and Order 15 enables the court to pronounce judgment at the first hearing in certain cases. Orders 16 to 18 contain provisions for summoning attendance and examination of witnesses and adjournments. Order 19 empowers the court to make an order or to prove facts on the basis of an affidavit of a party. Order 75 to 78 Part 3 and Order 26 make provisions as to issue of commissions. Order 94-95 Part 6 and Order 38 provides for arrest of defendant and attachment before judgment. Order 39 lays down the procedure for issuing temporary injunction and passing interlocutory orders. Order 40 deals with the appointment of receivers. Order 25 provides for security for costs. Order 23 deals with withdrawal and compromise of suits. Order 22 declares effect of death, marriage, or insolvency of a party to the suit. After the hearing is over, the court pronounces a judgment. Section 33 and Order 20 deals with the judgment and decrees. Section 34 makes provision for interest. Section 35, 35A, 35B and Order 21A deals with costs. Part 4 and Part 5, Section 79 to 93 and Orders 27 to 37 lay down procedure for suits in special cases such as suits by or against government or public officers. Section 79 to 82 and Order 27. Suits by or against aliens, foreign rulers, ambassadors and envoys. Section 83 to 87B it relates, and suits by or against soldiers, sailors and airmen, that is written in Order 28. Suits by or against corporations, that is on Order 29. Suits by or against partnership firms, written in Order 30. Suits by or against trustees, executors and administrators, written in Order 31. Suits by or against minors, lunatics or persons of unsound mind, Order 32. Suits relating to family matters, written in Order 32A. Suits by indigent person, paupers, for leave to sue, written in Order 33. Suits relating to mortgages, written in Order 34. Interpleader suits, written in Section 88 and Order 35. Friendly suits, written in Section 90 and Order 36. Summary suits, written in Order 37. Suits relating to public nuisance, written in Order Section 91, and suits relating to public trusts, written in Section 94, and Section 89 as interested from 1st July inserted from 1st July of 2002 provides the settlement of disputes out of court through arbitrators, conciliation, mediation and lok adalats, that is to recognition of the ADR, alternative dispute resolution. Part 7 and Part 8, Section 96 to 115 and Orders 41 to 47 contain detailed provisions for appeals, references, reviews and revision. Section 96 to 99A and Order 41 deal with first appeals. Section 100 to 103 and Order 42 discuss law relating to second appeals. Section 104 to 108 and Order 43 contain provisions as to appeal from orders. Section 109, 112 and Order 45 provide appeals for Supreme Court. Order 44 enacts special law concerning appeals by indigent persons, paupers. Section 113 and Order 46 pertain references to be made to a High Court by a subordinate court when a question of constitutional validity of an act arises. Section 114 and Order 47 permit review of judgment in certain circumstances. Section 115 confers revisional jurisdiction on high courts over subordinate courts. Part 3, Section 36 to 74 and Order 21 covers execution proceedings. The principles of governing execution of decrees and orders are dealt with section 36 to 74, that is substantive law, and order 21, that is procedural law. And order 21 is the longest order covering 106 rules to be remembered. Part 10, section 121 to 131 enables High Court to frame rules for regulating their own procedure and the procedure of civil courts subject to their superintendence. Part 11, section 132 to 158 relates to miscellaneous proceedings. Explanation to section 141 as added to Amendment Act of 1976 clarifies that the expression proceeding would not include proceedings under Article 226 of the Constitution. Section 144 embodies the doctrine of restitution and deals with the power of courts to grant relief of restitution in a case a decree is set aside or modified by a superior court. Section 148, as inserted by the Code of Civil Procedure Amendment Act 1976, is an important provision which permits a person to lodge a caveat in a suit proceeding instituted or about to be instituted against him. It is the duty of the court to issue notice and afford opportunity of hearing a creator to appear and oppose interim relief sought by an applicant. Section 148 to 153A confer inherent powers in civil courts. Section 148 enables a court to enlarge time fixed or granted by it for doing any act. Section 149 authorizes a court to permit a party to make up deficiency of court fees on plaint, memorandum, and of appeal, etc. Section 151 is a statutory provision. It slaves inherent power in every court to secure the ends of justice and also to prevent the abuse of process of this court. Section 152 to 153A empower a court to amend judgment, decrees, orders and other records arising from accidental slip or omission. Section 153, as added by the Amendment Act of 1976, expressly declares that a place of trial shall be open for the public. The proviso, however, empowers the presiding judge, if he thinks fit, to order that the general public or any other particular person shall not have access to the court. So, in this segment, this code at a glance, this only says about the whole code and says about the content of this whole code of civil procedure. We will go through every of these orders and sections, each of them individually, and on the next segment we will start the definition clause, that is chapter 2 of the introduction, and we will start from decree and we will do until the partly preliminary and partly final decree. So till then, if you have any problems, please do comment on the comment box and like and share this video. And if you have any problems, as I have said, I'll try to solve them as soon as possible. And do subscribe and wait for more videos.